On the last episode of Off the Clock, Rebecca and Sarah began a discussion on the latest EEOC guidance on harassment. Here's a brief recap.
Both sexual orientation and gender identity are classes protected by law. Here are the types of behaviors that they specifically identified could constitute harassment if severe and pervasive, okay?
Okay.
The first one is intrusive or invasive questions. Repeated / intentional use of pronouns or names inconsistent with that employee's own gender identities. Requiring employees to dress according to their birth sex rather than the gender with which they identify. Disapproval of somebody's protected class. So coworkers expressing disapproval of an employee's sexual orientation or gender identity, or perhaps telling them that they should adhere to a different set of beliefs. And then the last one is refusal to allow employees to use bathrooms or locker rooms.
Yeah, that's where the
align with their gender.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
So, with those, I see for our listeners, they're thinking to themselves, boy, I see conflict ahead of me. Right?
Yes.
Do you agree?
I agree, and I think a lot of them have already faced it, based on the calls I've been getting, and in two areas.
Yes.
One is the space where individuals' sincerely held religious beliefs
absolutely
may bump up against what we just discussed the EEOC's positions are. And the other is when coworkers express what seems to be genuine discomfort or just to say discomfort with sharing bathrooms and locker rooms with individuals who are transitioning. And whether we agree or disagree that the coworker should be bothered, it seems that they genuinely are. And so how do we balance
So let's take that first one first, because the commission did acknowledge this, boy, all I can do is this, right? The conflict between, on one hand, it being potentially unlawful harassment for coworkers to refuse to use an individual's preferred pronouns and names.
That's a good example.
Misgendering employees.
That's a good example, right?
On one hand, and on the other hand, an employee's sincerely held religious belief that they establish, that they claim would prevent them from doing that.
Yep.
Right? And literally we have this.
We have a work requirement to do something.
Yes.
That someone else has. By following that work requirement, I will have to violate my sincerely held religious belief.
I mean, you've got rights and you've got rights. You've got an employee's right to have a sincerely held religious belief and to request an accommodation, which is to not use somebody's preferred pronouns. And then you've got the rights of an employee on this hand. And I'm just seeing HR folks go, what am I supposed to do?
Yeah, that's legit confusion.
What am I that's legitimate.
And the EEOC, by the way,
here's what they had to say.
With protecting both of those interests.
They would take both charges.
Yes.
To be clear.
They're there to protect, both sincerely held religious beliefs and individuals' gender identities and sexual orientation.
And they didn't provide much help. Not surprisingly.
We set it all up. Here's the problem. And then the EEOC was going to give the solution.
Here's what they had to say in the moment. And then I do want to talk a little bit about what to do with this. But here's what they had to say. While sincerely held religious beliefs should be protected, employers aren't required to accommodate religious expression that creates or reasonably threatens to create a hostile work environment. So read on its face, I read them as saying, arguably, employers do not have to accommodate a sincerely held religious belief that would cause an employee to misgender another trans employee.
So the harassment, hostile work environment issue trumps.
That's
it's
what
the
it sounds
tiebreaker,
like.
right? When there's a tie there, the tie goes to making sure the work environment is free of harassment.
Now, I will say this line of case law is developing literally by the day.
Yeah. Oh, yes.
And employers
Hot
need
topic.
to take that with a grain of salt.
And this isn't even case law. Let's put this in perspective a little bit.
This is guidance. It's not case law.
This is how the EEOC views it.
Correct.
Mm-hmm.
So that is the current position of the commission. Okay, current. That could change as well. I don't necessarily agree that every case or that every court would follow that, particularly with the higher standard for showing undue hardship with regard to religious accommodation now.
Yes.
And so listeners, please understand that's what the EEOC had to say in this guidance. But when faced with those difficult situations, really you're going to want to know exactly what's happening in the courts where you are, what the case law is, and be managing those case by case.
So that's the
That's
advice.
my takeaway, call your lawyer. Yeah. That's my nice way of saying.
Our marketing department thanks you.
Of saying that statement in the guidance, although it provides a little bit of context, I would caution any business from taking that and running with it and making the assumption then that always that one trumps the other in all cases and circumstances.
I could not agree more.
Yeah.
Moreover, in addition to the shifting legal stance in this area, and sometimes conflicts between two legal authorities, the EEOC and the court, it's all so very fact specific, And maybe there's even a practical solution that we could find here, right, that could bypass that conflict.
Yep.
So I am not a fan of clients needing to call us every single time something comes up in the workplace. That's not a good use, right, of their legal spend that could be used to provide benefits to their employees and everything else. However, that is one of those times when it's time to pick up the phone and get
I agree.
Someone, whether it's us, whether it's an advisor, whether it's someone, but get someone else's opinion on that.
Yep, exactly.
Yep.
So, okay. And then with regard to the bathrooms, you mentioned that
boy,
one.
have I been getting those questions.
Yeah. And interestingly, also often in conflict.
Yes.
Right? For example, female employees saying, I feel harassed or unsafe because there is somebody who I believe by birth is a male and they are in my locker room space watching me change. And so I feel harassed. But the trans employee, if not allowed to be in that space, arguably has their own claim of harassment. Welcome to the world of HR right now.
What is an employer to do?
What is an employer to do?
We know what the EEOC would say, which is not what we're going to say. The EEOC would say you have to tell the employee that feels unsafe or uncomfortable, too bad. Get used. This is the world you live in.
Right.
Get used to it. That is one approach. That is an option for employers, and that is, according to what the EEOC says, the correct statement of the law. But I am aware of organizations that it creates quite a distraction and tumult, and sometimes people quitting and other things, which is not good for anyone, including the trans employee, by the way. Right? I won't go on and on, but that I do not believe is anyone's intent to make other people uncomfortable, cause disruption in the workplace, etc. So when I have those conversations with clients, I tell them what the law is because they called a lawyer after all. But they're not going to get their money's worth if they don't hear me say what the EEOC has to say about it. But turn quickly to a practical solution.
Yep.
Just get practical. Right? Create unisex bathrooms or changing areas. Maybe no one changes at work. Right? Or if you have to create, and it doesn't have to be a space only set aside for that purpose, but make sure everyone knows they have options other than the locker room. Right? You can use the manager's office. You can use the the back storage, right? Get creative, come up with a practical solution.
Right.
So that people can feel comfortable at work.
Maybe in the workplace, we just don't take our clothes off in front of each other anymore at all.
Why hasn't that always been the rule?
I don't know. It's a new world. It's a new world.
It's always been my personal rule. Back to kindergarten, right? Don't touch each other. Yeah. Don't play doctor unless you work at a hospital.
All right. All right. Well, let's turn to the second piece and then talk about a takeaway that I think would be good for our listeners to hear. So the second piece is much quicker to explain, right? And that is the EEOC's view on harassment that occurs in virtual settings. I know you hate that word, but I don't have a better way to say it, right? So inappropriate comments that get made, for example, over Zoom or in Teams meetings or in chats, etc.
Or on social media or by text or
whatever it is.
All the ways we communicate.
So no big surprise, right? No big surprise. They said, yes, that still can be unlawful harassment, even though it's not said face-to-face to a person. I don't think any of us probably doubted that was the case. But then in their discussion of that, they slipped in this comment that was interesting. And what they said is electronic and social media posts that target another employee can contribute to a hostile work environment, even if they're posted from a personal account, from the employee's own cell phone or computer at home outside of work. Right?
That also does not surprise me.
It doesn't surprise me, but I think it would surprise some HR folks. And the principle that the commission is using, and I know it's similar to what you and I have been using for years, which is if it impacts the workplace, right, even though it happened outside of the workplace, once it makes its way back into our four walls, that is now potentially our responsibility.
Right. The way I say it in trainings, and someone recently mentioned they like it. They like this phrase, so I'll say it now. It's not our business until it impacts our business, and then it is our business.
And then
So we're not going around following everyone's social media posts. That we don't have the time or interest to do that. But once an employee raises that to our attention, that it's a problem and impacting their ability to work, now it's our business.
Yes.
Right?
So what that means then is that if an employee comes to HR and says, I saw Rebecca posting lots of comments about her support of X, right? And I am personally offended by that. And I feel harassed, okay? That is, to your point earlier, that could be harassment. Not something to be brushed off automatically just because it happened outside of work.
Doesn't mean it will always be harassment.
Doesn't mean it will always be. Doesn't mean somebody's getting fired for it.
Right.
But shouldn't be brushed off solely on the premise that it was said outside of work and therefore it doesn't matter.
Right. Correct. That's also a time to reach out for counsel, right? Because that can be very tricky.
It can be tricky. Yeah. And just really to layer it on for our listeners, right?
Just to make things worse.
Remember, they're having this pressure from another place, which is the NLRB, telling them that they are limited in what they can tell employees about expression.
Yes.
And social media policies, et cetera, because that could chill their right to engage in protected and concerted activities. So we're juggling all of these balls at the same time. So to your point, when a concern like that comes in, it needs to be managed very carefully.
We can't give you all the answers as every situation is so specific. The one answer, the takeaway we can give you is it's not a brush off. It's not a, that was on someone's own personal email or Facebook
Therefore,
account.
it doesn't matter.
Therefore, I'm not going to continue the conversation with
Exactly.
you. That should not be the response.
That should not be the response.
Right.
That's
that we can say.
Right. Yeah, exactly. Okay, so let's talk about a takeaway here. As I'm thinking about managing all of this, right? We've used the word conflict a lot in this conversation, right?
We have.
Managing these workplaces. You and I have talked frequently about this idea of setting we call them different things, ground rules, employee engagement rules, et cetera, sort of having the organization's North Star to go back to,
phrase.
Right?
Yeah.
When employees are conflicting with each other.
Yeah.
These basic expectations of how we expect everybody to communicate with each other and treat each other. Man, I was thinking about that the whole time I was reading this new guidance from the EEOC and thinking how important it is for employers to have something like that. It's not something that I think most businesses have right now. It's not a harassment policy, right? It's something else.
No, right. Why don't we tell people a little bit more about what we mean by, because I know what you're what you're talking about. And it's we don't have a great title for it. And it might be a conversation. It might
the
be
North Star.
It might be town hall meetings. It might be other types of things other than a policy and a handbook. The concept is, why are we all here in this place together? Right? And that's going to be different organization by organization, obviously. At Miller Johnson, it might be to provide exceptional legal services to the communities that we serve.
Yeah, what's our mission and our purpose?
Our communities. It might be to provide health care or improve the health, right, of the communities that we serve. It might be to dominate the market in this type of widget because it is the best widget, right? And people will be better served using our widget instead of our competitor. So it could be anything, depending on what your organization is designed about or designed to do. And then the message is that really is why we're all here together. We all share that in common. So you focus on what we all share in common. And we're not going to always agree or have in common many other things with our colleagues.
Right.
Right?
And I think acknowledging that
but that's
they
not why
don't
we're
choose
here.
each other.
That's not why we're here.
Right. And that's not why we're here.
This isn't a club, right? We all have clubs or churches or other things that are structured around shared religion, shared values, shared environmental goal, but here, this place is about our North Star, as you said, which I love. I would say our purpose, however you want to say it. When you're in those other organizations that are organized around shared interest or characters, you don't care what people do for a living, whether they make a widget or work in a hospital, right? Because that's not why you're gathered together. Mm-hmm. So if we apply that concept at work, and then we talk about with that in mind,
right?
How do we engage with each other?
Right. And what are
when we know there are differences?
For everyone.
We know that.
Right.
That is not a surprise. That's not an exception. That is a truism because we are all individuals. Therefore, we are all different from everyone here, and sometimes we may have disagreements about things that are important to us.
Right? And how do we expect employees to manage those? Yeah. How do we expect them to communicate with each other? How do we expect them to engage with each other? When these conflicts arise, I think many times focusing first on that can get you to where you need to be.
Right. Level set.
And avoid but my religion is this, but I'm trans, right?
Right.
And instead say, okay, let's level set and let's talk about our expectations about how you're supposed to treat me and how I'm supposed to be treating you, and see if we can address it through that lens instead. That is not a solution every time, but I do believe it would be incredibly helpful for organizations to have something like that to go to first. Mm-hmm.
Yes.
All right.
Thank you. This was great.
This was wonderful. Thank you for talking.
It's never a problem.
Thank you, Rebecca.